The next case to come before the court is State of Ohio versus Johnathan Kirkendoll. Again, you'll both have 15 minutes. Attorney Bremke, you want to let me know how much time you want to reserve?
I will reserve 5 minutes if I could.
Okay, and you can go ahead whenever you're ready. We've read your briefs and we're ready when you are.
Sure. Again, Giovanna Bremke on behalf of Johnathan Kirkendoll. And Mr. Kirkendoll, there's 5 assignments of error. Mr. Kirkendoll was indicted on 10 different counts. He was arrested in, I'll give you the dates because of the speedy trial argument, but September 23rd of 2018, he was offered before the trial court judge 3 years, and the trial began on January 14th, 2019. He was convicted on almost all, not the first count of the indictment, but I believe the rest of the charges. And all of them stem from an incident involving a girlfriend and his involvement with that girlfriend. The case proceeded to a jury trial, I should say. The first assignment of error is that Mr. Kirkendoll received ineffective assistance of counsel in violation of the Sixth Amendment right to counsel. His counsel proceeded to a jury trial, having filed no motions, actually not having received any discovery at all. That's clear from the record. He was unprepared to question witnesses. In fact, this involves Mr. Kirkendoll's then girlfriend. At the end of the girlfriend's testimony, defense counsel has a sidebar with the prosecutor and the judge and says, essentially all this testimony was a surprise to him because, again, he had not received any discovery. He didn't have the witness statement. There was a surveillance video that he didn't have that was important in this matter. And again, the way it's portrayed in the record is that it was a strategy in order to not eliminate the speedy trial argument. The difficulty with that, and it's going to sort of tie into I believe it's the 4th assignment of error, which is the speedy trial. And what I argued on that is that the speedy trial had actually expired on December 22nd. It didn't proceed to trial until January 14th. So the strategy of not requesting discovery after the 22nd of December, he could have filed for discovery, and his time, again, there was no tolling event because there was no motions filed. So his time under that could have expired. He also didn't file, he made an oral motion to dismiss based on speedy trial, but didn't necessarily pursue the speedy trial route. If the strategy was to not eliminate the speedy trial argument, it wasn't effectively done. There was no written motion again, and could have been done after the expiration. There was certainly about more than 15 days, about 20 days, in which after the speedy trial time had run, that he could have filed these motions and not told any time event. He also failed to object to, in the jury instructions there was the first 2 counts of burglary. He failed to object to the recklessness as a mens rea in the 2nd count. Mr. Kirkendoll was convicted of the 2nd count and not the 1st count, which didn't include the recklessness.
So I have a question about that. Maybe I could answer myself if I could access the paperwork. What was the difference between the 2 counts in the indictment? Was recklessness in the indictment?
No, I believe my recollection of the record is that the state had asked for the recklessness to be included on the 1st, and or had asked for the recklessness to be included on it, and it wasn't objected to.
And that's the one he got convicted of?
Yes.
Thank you.
The second assignment of error is that the trial court judge, he was denied due process in the fact that the judge was vindictive in sentencing Mr. Kirkendoll. Again, the offer about 4 days prior to when the trial began was a 3-year sentence. The trial court judge says, I'm offering this based on solely on my limited knowledge of your charges and your prior record. Then, once it comes time for sentencing, and again, these assignments of error are kind of intertwined because of the consecutive sentencing, which is my third assignment of error. When it comes time for the consecutive sentencing, when he does get sentenced, he says, well, your record is the reason I'm giving you consecutive sentences. But again, that record was already known in the plea discussions. So I think it's clear that there's actual vindictiveness because of the fact that the trial court judge says, I know of your record, and then later on, he's saying, well, because your record's so bad, I'm gonna give you more additional time. But that was already known prior, and the record's clear of that.
But that wasn't the only reason that he stated he gave him additional time.
I believe because I believe it was also because of the separate nature of the offense, was one of the other, on the consecutive sentence, justification.
Isn't that a risk that a defendant always takes when they go to trial? And I think this trial judge addressed that right now this is all I know. I know more after I hear a whole trial. It could be good for you or it could not be good for you.
Sure, that's a risk. But again, that's when we look at the actual vindictiveness and the fact that the record was known beforehand. And so to use that, the separate offenses maybe wouldn't be known, but the record certainly would be known. And it might not have been the only reason, but it was one of the reasons, and that's enough to show the actual vindictiveness. The third assignment of error is the consecutive sentences. There wasn't a finding, the required finding under 29-29-14C4 of that the consecutive sentences are necessary to protect the public and to punish the offender, and that the consecutive sentences are not disproportionate to the seriousness. He didn't make this required finding. That's transcript page 321. That's clear from the statute that needs to be found, both that initial finding and then the additional 29-29-14C4 A through C factors that, again, that's clear that that's what the law is. The speedy trial, I want to get to before my time's up. Again, I sort of addressed this, the 90 days, there was no tolling event. The 90 days, if you calculate from the date of arrest, which was September 23rd, until the day the trial began on January 14th, the time would have expired on December 22nd. And he was not taken to trial until January 14th. The state argues in the trial court that that the triple count rule doesn't apply because he was being held out of the Lorain Municipal Court. But the state doesn't present any argument to that effect. In fact, it's not even real clear. It says the state says it's my understanding that he's actually sitting on a case out of Lorain Municipal Court, but that's not enough. If you look at the Green case, where they're saying there was a parole holder in that case, but they were saying there was no one from the sheriff's office to testify to that effect. The holder wasn't presented to the court. This court says I've looked at the record and it's clear that he's being held 1-for-1. But there's nothing in the record. There's nothing. A municipal court holder would not be in this trial court record. It's not in the record. So to say to look at that, the state didn't meet their burden. It's their burden. Once the defendant raises the issue, which if you look on page 15 and 16, the defense counsel makes an oral motion to dismiss based on that speedy trial. Once that's raised, it switches to the state to prove, and it wasn't proved at all. There was actually no evidence to that effect.
But if the other side agrees or is a holder?
I don't, yes, and I don't know that, again, it's a difficult position for me because, again, I believe it was ineffective assistance of counsel, that should have been pursued, more fully, so. And the last is that the verdict for the menacing by stalking is against the sufficiency of the evidence because it requires a pattern of conduct.
You're under your 5 minutes.
Okay. The indictment and also jury instructions only mentioned one day, August 17th, 2018, not a pattern. Now, there was some testimony of some other incidents, but that wasn't included in the jury instructions, and the jury was not instructed they were instructed to review a pattern of conduct, but was only given the one date, and there wasn't enough on that date to establish a pattern of conduct for the menacing by stalking charge. So I would reserve the rest of that.
Okay, thank you.
Again, Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office, for the record. Addressing first the speedy trial issue, judges, Mr. Kirkendoll failed to establish a prima facie case that his speedy trial rights had been violated. The burden only shifts to the state once the defendant raises the issue sufficiently. The defendants don't get to just walk into court and say, prove that you have met the speedy trial requirements. That's not sufficient. The burden's on the defendant to show that he or she is in jail in lieu of bail, and this is the critical phrase, on the pending case, as the statute says, as the Supreme Court said in McDonald, solely on the pending charge. I'm sorry, the statute says, on the pending charge, the Supreme Court in McDonald, 40 years ago, said solely on the pending charge. Of course, the statute grants 270 days to bring a defendant to trial. That really applies whether that defendant is in jail or he is not in jail. That's our jumping off point. That's the default, 270 days, until the defendant makes the showing that he is in jail in lieu of bail solely on the pending charge. It is incumbent upon the defendant to state solely the pending charge is keeping me in jail. At that point, the burden shifts to the state, and it's only after sufficiently alleging a speedy trial violation, including being incarcerated solely on the pending charge. If you look at what Mr. Kirkendoll's attorney said, and I quote, "On behalf of my client only, he has argued that the time he was sitting had not told his case's time, and he wished me to put on the record that we are past the 90 days to bring him to trial. There is not only 90 days to bring him to trial. There are 270 days to bring him to trial." What Mr. Kirkendoll's attorney said, when you read that record, it almost gives the impression that he was embarrassed to be saying this to the court. It's very cryptic. It's very vague. It's not very authentic. It feels spurious in its presentation to the court. 90 days had passed, and there's a discrepancy in what he says between tolling and being in jail in lieu of bail solely on the pending charge. The two are different analyses between tolling and the triple count provision, because the triple count provision can still apply while still working in certain tolling instances. And of course, tolling can certainly apply without the triple count even being invoked on defendants that are out of jail. But this is a half-hearted motion. It doesn't even indicate that the attorney doesn't really even indicate that he's making a speedy trial motion. He's not asking that Mr. Kirkendoll be discharged. In this case, despite the trial court's ask of the state, legally, the burden never shifted to the state. The state directs this court, on this issue, I think it could be perceived sort of as I guess a first impression, but Gagaris, in State versus Gagaris, the second district declined, held that when moving for discharge, defendants must first allege they are being held solely on the pending charges before the state must prove that defendants are not entitled to the benefit of the triple count provisions. And that's an explicit affirmative statement, is what Gagaris said, of solely the pending charges, keeping the defendant in jail in lieu of bail.
Did Mr. Kirkendoll's attorney object to the discussion about him sitting on a case out of Lorain Muni?
Interestingly, no. No. The facts of Gagaris actually are very similar to the facts of this case. The attorney simply argued in Gagaris that Mr. Gagaris was incarcerated, not tried within 90 days. He did not, or the attorney did not argue that Mr. Gagaris was solely in jail solely on the pending charges. There was no notice to the state before the oral motion in open court. And the state recognizes that under the statute that there's nothing wrong with that it does allow for that motion to be made day of trial. Also that Mr. Gagaris didn't rebut the state's argument regarding the state's argument that the triple count didn't apply because of a parole violation hold. But what Gagaris said is mere incarceration itself doesn't trigger that triple count provision. The court reasoned that it's unreasonable to impose on the state the burden of proving that a defendant's incarcerated solely on the pending charge before a defendant even alleges that he or she is incarcerated solely on the pending charge. The second district pointed out back in 2002 when this opinion came out that if a defendant doesn't argue that he or she is in jail solely on the pending charge in lieu of bail, the solely on the pending charge phrase being the critical phrase here, that arguably, defense counsel could make a judgment to specifically keep that information out of the argument, knowing that it still needs to be one of those satisfied elements. And again, why should the state rebut allegations that are not specifically asserted? The simple fact that a defendant fails to allege, defendants fail to allege they're in jail and bail solely on the pending charge means the motion should and must be denied. The state's asking this court to hold that before the state can be compelled to show defendants do not enjoy the protections of the triple count provision in the speedy trial statute, defendants at a minimum must make a reasonable good faith allegation that they are entitled to the benefit of the triple count provision by affirmatively and explicitly alleging they were held in jail more than 90 days in lieu of bail solely on the pending charge or charges. This is not a burden to the defendant. The state receives exact notice of the grounds for the defendant's motion, and it ensures that the trial court, and ensures for the trial court that the defendant has exercised due diligence before making a motion. And that's going to ensure fair, efficient, and just resolution of cases. It's going to avoid unnecessary hearings where a defendant says, I've been in jail, I haven't posted bail, and it's been more than 90 days. Now the state has to go and prove that it's solely on the pending charge. It does not, that the defendant is not in jail solely on the pending charge, when that's something that's just as obvious, and perhaps even more obvious to defendants than to the state. The state, as I've pointed out, recognizes that, for lack of a better word, but defense counsel has every right to sort of ambush the state with this motion, and that's zealous representation. We can appreciate that from the law. But if this ambush is going to occur, the defense should have the obligation of researching the motion, the grounds for the motion, and should, at a minimum, be really close to being right, if not being held to be correct, because no one's really was prepared to argue this motion. Actually, from the record, it didn't look like anyone believed the motion was well-founded and grounded in any facts. Even presuming that the burden did shift to the state, the trial court did rely on records. The trial record shows that Mr. Kirkendoll was not incarcerated in lieu of bail solely on the pending charges. So that would be that he was being held on other charges. He was not solely, the sole reason for his being held in jail was not the pending charge and the failure to post bail. Defense counsel, judge, as you asked, did not dispute or object to this assertion. We'd also point out, the state does, that defense counsel chose this trial date. According to the prosecutor in the record, he was aware that his client, Mr. Kirkendoll, was incarcerated on other charges. Also, the standard here is clearly erroneous. Was the trial court's decision based on the facts clearly erroneous? It's the state's position that the trial court's decision cannot be deemed to be clearly erroneous, that there is information that the trial court relied on. Now, perhaps it wasn't as fully developed as it could have been, but it would not, it's the state's position that this court should not find that the decision was clearly erroneous, and I'm confident that the trial court was correct. Trial could have proceeded without issue in this case. Moving on to the consecutive sentences, all that's required is for this court to be able to discern that the trial court engaged in the correct analysis and to determine the record contains evidence to support the findings. It's the Supreme Court's holding in Bunnell. I've said that wrong, I'll admit. Here, I think the trial court can do that, and I think that the brief sets forth that when you line up the findings that the trial court could have made word for word, but it's not required to. Again, that's Bunnell. A word for word recitation is not required. But if you line up what the trial court, what the statute requires versus what the trial court said, this trial court can discern. This court can discern that the trial court was making an effort to comply with the consecutive sentence findings in 29-29-14C. Also with regard to the vindictiveness of the sentence, it's really a two-part test. Did the court make statements from which it can be inferred that the sentence was increased due to a defendant's decision to proceed to trial? There are no statements in the record from the trial court that the sentencing was based on the defendant, Mr. Kirkendoll's decision to go to trial. The sentence was increased, I think, as you pointed out, Judge Callahan, not because Mr. Kirkendoll chose to go to trial, but because of the facts that came out during trial and also the sentencing hearing, those facts coming out because he went to trial. The trial court learned the victim's testimony where she testified multiple times. She was scared and in fear of Mr. Kirkendoll, and also at sentencing about the traumatic effects on her young daughter. Should also point out that Mr. Kirkendoll heard from the trial court judge that his sentence, if he went to trial and were found guilty, might be more, might be less than 3 years. And the trial court even pointed out to him that he may not get a sentence if he was found not guilty. The pattern of conduct argument, 2 incidents occurred on August 17th, 2018. The first, when the victim was in her apartment, Mr. Kirkendoll demanded her cell phone, threatened to beat her to death or kill her. There was a subsequent altercation in the hallway. She left her young daughter back in the apartment. She never went back to the apartment, but video surveillance showed later that day Mr. Kirkendoll returned to the apartment and kicked the apartment door off the hinges and entered the apartment. That was the basis for the burglary charge for which he was found guilty. There were 2 instances of that amount to a pattern of conduct on August 17th of 2018. Judge, I believe with regard to the first ineffective assistance of counsel, that counsel was damned if he did and damned if he didn't. I believe that's a legal way of putting it, but trial counsel honored Mr. Kirkendoll's wishes regarding discovery. It's Mr. Kirkendoll's own fault. With regard to whether Mr. Kirkendoll's attorney should have filed a motion to dismiss, the state points out that the record does not anywhere reflect the arrest date of September 23rd. In fact, the common police court docket indicates an arrest date of October 1st. And that's in the docket sheet, which I reviewed.
With that, time is up.
Thank you, Judge. We'd ask that you affirm the convictions and sentences.
A little over 4 minutes.
Again, I want to point out the ineffective assistance of counsel argument, because a lot of what the state just argued was, and I wrote down some things, that no one was prepared to argue this speedy trial argument, that the defense counsel chose the trial date, that it was a half-hearted motion, and all of that sounds to me like ineffective assistance of counsel.
Well, counsel, let me ask you this, and obviously we don't know, but when you sit on this side of the bench in a trial and you hear an attorney say, my client would like me to ask you for bond on his 6-count aggravated murder case, signature bond, or my client wants me to put this on the record. Sometimes it's kind of an indication that maybe trial counsel has to act in good faith and can't present things that are frivolous. So where's the balance there?
So I'm glad you mentioned it, because I believe that our job as attorneys, especially defense counsel, is to honor our client's wishes to the extent that we ultimately have the discretion for trial strategy. So there are certain things, obviously, that is solely ethically and legally the client's decision. But as far as trial strategy goes, and you can certainly honor your client's wishes while also maintaining multiple strategies. Like I said, the time had lapsed according to the record and according to what defense counsel had calculated on December 22nd. There was about 20 days there where motions could be filed, and it wouldn't have told any event because the time had gone under his calculation at that point. So again, in honoring the client's wishes, in presenting the speedy trial argument, but also presenting a strategy that would have been effective at trial, being able to be prepared for trial at that point.
Is there a difference here on the speedy trial when the state said, it's our understanding he's being held for Lorain Muni? Is there a difference between defense counsel saying, yeah, it's my understanding we have 270 days, and defense counsel saying, I have no idea whether he's being held? I mean, wouldn't it suggest that defense counsel actually was aware of another case in Lorain Muni?
It's possible that he wasn't aware that there was another holder, although I would find it unlikely that, that conversation didn't come up before. The fact that speedy trial wasn't waived from the beginning, that those conversations weren't had. Again, to proceed to a jury trial in which there's video, in which there's a witness, in which there's a witness statement, and that witness is the, ultimately the only, there was another witness of the apartment complex, but the key witness in the trial, and to not reviewed those witness statements, maybe not even known who the witnesses were who were going to testify, other than what you find out from your client, it's ineffective in order to proceed. And again, there was a possible way to preserve that right to speedy trial in that argument, even if it was just to appease the client, although again, the state didn't meet the burden on that argument either. But there's a way to do that in this case and also proceed with having discovery. There was a time frame there of 20 days in which it would have been difficult to prepare for trial, but certainly been more prepared than what he was going forward.
With that time's up. Thank you. All right, thank you both for your presentations. We will take the matter under advisement and issue our decision, which will be posted on our website and as the Supreme Court's website, and of course mailed to both sides.